Archiving started.
Welcome to the second lecture covering Chapter 10 of our textbook, and that chapter addresses the issue of conducting interviews and investigations. During the first presentation, I covered the first 10 slides in the PowerPoint, so I'm going to jump immediately to slide 11. Here we're going to talk about interviewing witnesses. During the first 10 slides, we focused on talking about interviewing clients, although many of the things we said about clients would also apply to interviewing other types of witnesses. But when we talk about interviewing witnesses in this context, we're really focusing on interviewing individuals who are not also our clients. And they can be broken down, the categories of witnesses each interview, into three categories. For the most part, the category lay witness and eyewitness, for the purpose of this class at least, can be rolled in together. So one way of looking at it is to look at expert witnesses as one category and non-expert witnesses as another category. Well, let's first of all define what an expert witness is. An expert witness has specialized knowledge, and this is usually based upon some type of professional training. Usually they're going to be an MD, a medical doctor, or a dentist, a DDS, or a scientist, oftentimes a PhD. But they don't have to have professional training. If you are hiring an expert to talk about how bricks ought to be laid to establish a good facade on a building, there's no one out there that has a PhD in laying bricks. You'd want to have somebody that has significant experience in that area. So while you ordinarily expect some professional training with lots of credentials and letters after their name, you can also have substantial experience. But the training or the experience or both have to be related to the issue at hand. So let's imagine for a second that a doctor observes a car accident and he sees what happens at the time of the car accident. Well, he would be an eyewitness. He would not be an expert witness because he hasn't received any particular training in the flow of traffic or the safety rules or the mechanics of how cars function. Now, of course, if he rendered emergency aid, let's say one of the people in the accident was significantly injured, he continues to be an eyewitness. He observed the injuries, but he might also be able to use his expertise to talk about the severity of the injuries, what perhaps caused the injuries, that type of thing. So the point I'm trying to leave you with is that an expert, that all of us may have an area in which we are an expert, but we also have lots of areas in our life where we're not an expert, where we're either a lay witness or an eyewitness. And again, let's not worry too much about distinguishing those two categories for the purposes of this class. We've already talked about in Lecture 1 about the distinction between a friendly witness and a hostile witness. It has nothing to do with how charming the witness is or how nice the witness is to you. You can have a hostile witness who's very friendly and charming, and you can have a friendly witness that's downright unpleasant. But it has to do with the inclination that witness has. Is that person inclined to be on your client's side? Or perhaps the person is inclined to be against the other side. You know, the old saying, the enemy of my enemy is my friend. Well, sometimes that works out in litigation. Similarly, a hostile or adverse witness is on the other guy's side. He or she may be charming and helpful, but his inherent loyalties lie with the other side. We already talked about the four types of questions that we can ask witnesses or clients, and we talked about them being open-ended, closed-ended, leading questions, and hypothetical questions. We already discussed how open-ended questions are going to be the majority of the questions that you ask during an interview. You'll probably lead with open-ended questions, and you may ask some closed-ended questions to tie down some facts that haven't been answered through the open-ended question. And occasionally you might find it necessary to use a leading question or even to ask a hypothetical. But most of your questions are going to be open-ended. It's a good strategy. One of the things that you're likely to want to do is confirm the witness's qualifications to be a witness. One issue that can come up is the witness competent to testify about what he or she is going to testify to? Usually a lay witness is pretty obvious. They saw something or they have firsthand knowledge about something. Maybe there's a keeper of records. There's a records keeper at a hospital, and so they are the custodian of the records relating to the medical bills that or the medical records that this particular person had relating to the accident. Usually those are pretty straightforward questions. With an expert witness, it can be a little bit less certain. For example, I might be a medical doctor, but perhaps I'm a ophthalmologist, an eye specialist. So, and let's say I have been called in to evaluate the compound fracture that Mr. Green has in his left leg. Well, I'm a medical doctor. I have an MD, but I don't. So I have some specialized knowledge about how the body functions. But my area of special training has to relate to the eyes. If it were an injury to an eye, I would be an excellent person. But very possibly, if my area of specialty isn't pretty darn close to the mark, I'm not going to be considered an expert witness for that purpose. So, and many times there's a lively debate about whether that person does have sufficient knowledge in the particular area that's relevant to this case to be able to be designated as an expert witness. Many times those are called, let me write this up here that you don't need to know for this test, but it's a word that you will see. It's called a Daubert issue. An important case about whether somebody is sufficiently trained to become an expert witness and whether their theories of the case are sufficiently scientifically proven to be able to be put into evidence. So we have the issue of competence. Is that person competent? A second issue is going to be their credibility level. Yes, they're allowed to testify, but just because they testify doesn't mean that the jury is going to believe them. If the witness has an unbelievable story, imagine for a second that Bob claims that he wasn't present at a particular event, but 50 witnesses were there, including a priest, a rabbi, a minister, an imam, and several other important and highly respected members of the community. And they all say, yep, Bob was there. And Bob doesn't have a twin, and there's no reason why those 50 distinguished people would lie about Bob being there. Well, Bob can get on the witness stand and say, oh, no, I was across town. Nobody can confirm that, but that's where I was. He is allowed, he's competent to testify, but he's not going to be very credible. The jury is going to say, Bob is lying. He was there. All these people who we find credible say that he was there. Things that might be relevant to credibility are the reputation of the witness. Now, the issue of reputation, whether it's admissible, is a complex issue beyond the scope of this course, but it is a category of evidence that the jury is obviously going to be interested in. And it's not just reputation, what people think about a person's character, but also what their character in fact is. And one issue that is often very relevant to this are prior convictions. Now, let's say that Bob is a 50-year-old man, and when he was 20 years old, he was charged and convicted with jaywalking on one occasion. Well, that conviction 30 years ago for jaywalking really doesn't point to a poor character. On the other hand, let's say Bob is being sued for a car accident in which the plaintiff is alleging that Bob was driving while intoxicated. And it ends up that Bob has had 2 previous convictions for DWI in the last 5 years. Well, those prior convictions would tend to point to, and let's say Bob is disputing, oh, no, I wasn't drunk, but those 2 convictions would tend to point to the possibility that maybe Bob is not to be believed regarding this particular issue. So with respect to prior convictions, the relevance of that subject matter, that conviction subject matter to the facts of the case, and how recent the case is, and how serious the misconduct is, all of those would be factors in whether that is admissible or not. Finally, we have the issue of bias, and this fits in to some degree with credibility, but credibility is usually a blanket look at a person. Is this person a good person? Does this person know what they need to know? And is this person likely to tell us the truth? Bias is a very fact-specific inquiry regarding this particular situation. Even the very nicest, best person has biases. If Mother Teresa were alive today and she were called to the witness stand, the judge might the attorneys might well point to some biases that she has. For example, perhaps one of the nuns in her order she was particularly close to, so she might be inclined to have a personal interest in that person's welfare. Now, everyone would say, well, Mother Teresa is a person above reproach. We certainly believe that she is believable. She's got a good reputation. She's got a good character. She has no prior convictions. But even a person like that has personal interest, and they have connections to other people in the case. And that can point to biases. Biases are not necessarily situations where the person is lying. or they're telling a story because another person wants them to tell a particular story. Sometimes biases comes up when a person is just inclined to believe their friend's story, or they're disposed to be sympathetic to that person's story. They believe it, and they're conveying that belief to the jury. A very helpful strategy that I have used when I'm interviewing witnesses and also when I'm interviewing my client is when I end the conversation, I say something like, is there anything else you would like to add? There are a couple of reasons why this is helpful. First of all, sometimes you'll have a witness that at some later point will say, well, you didn't ask me about that. Well, of course, going back to the example I used in the first video wherein I had Sally, the HR manager, talk to Bob, and let's imagine that Bob had shared the whole incident about the pocket knife at his throat. And when Sally had asked, Bob, did your boss Sue ever do anything inappropriate? And Bob had said, why, no. And then, of course, Sally had no idea about the pocket knife incident, so she couldn't ask any questions about that. And so she goes to the next question. Well, let's say months go by and the matter gets into litigation, and during a deposition or during trial, Bob volunteers this pocket knife story. And he's saying, well, Sue pulled a pocket knife on me. Well, of course, Sally is thinking, well, why didn't Bob share that story with me? But since Sally didn't particularly ask about that event, Bob could say, well, you didn't ask me about the pocket knife. And, of course, Sally's response is, I didn't know to ask. One way to reduce the likelihood of Bob being able to get out of his failure to be forthcoming with you is to end an interview, and you don't have to do it necessarily at the end, but do it again at the end and maybe do it throughout, and say, is there anything else you would like to add? Presumably, Bob would want Sally to know about this incident that he had with his supervisor about the knife in the throat. And if Sally writes that she asked that question, that she said no, then Bob is pretty much boxed in. Obviously, it wasn't that significant of an event to Bob if he didn't choose to tell Sally about it. So whether it happened or not, it probably wasn't as serious an incident as it might sound like, or the way Bob might be making it sound today. I would actually state it a little bit differently than this when I would do interviews with witnesses. What I would say, is there something that I need to know or you'd like for me to know that I haven't been smart enough to ask you about? That's the way I would phrase it. One of my styles of interview is trying to, as much as possible, make my witness feel at ease, feel comfortable with me. So a strategy that fits with certain people's personality, but not with everyone's personality, is to be a little self-deprecating, to appear, I don't say humble, that might not be the right word, but to appear approachable and human and fallible. And so I will say, is there something I've not been smart enough to ask about today that you'd like to share with me? And that gets them thinking. A lot of times they'll kind of giggle a little bit about that, and they'll more often than not, they'll say no. But every now and again, I've had people volunteer things. Well, you didn't ask me about this. And it can lead to some fruitful areas of inquiry. So you can actually find that information you wouldn't have otherwise, but you also kind of box in the witness. Now, many times your relationship with witnesses is complex. Even if it seems to be a friendly witness, sometimes the person who seems to be a friendly witness may not ultimately be a friendly witness. I had a situation once wherein I was representing an employer, and the employer had a facility, and there was, we'll call him Bob, different Bob than before. Bob is the boss of the facility, and under Bob is Mac. He's the number 2 guy in the facility, and there are several other employees in the facility, but there's one, we'll call her Sarah. Anyway, Sarah made a series of allegations about Bob and said that Bob was sexually harassing her, was doing a bunch of really kind of gross and weird stuff. One example I remember was that Sarah claimed that Bob put a dead rat in the drawer in her desk. Some pretty weird, unpleasant stuff, and was generally quite unpleasant when Sarah rebuffed his advances. Well, when you meet Bob, one's first impression is, yeah, I could see Bob doing something like that. Bob was a little rough around the edges, a little gruff, a little you could imagine that he might do that. Then I met Mac, and Mac was very charming, young, attractive, personable, poised, articulate. And Mac made it very clear from day one that no, that wasn't Bob either. Bob might be a little bit rough around the edges, but no, he was very respectful of his employees and never would have made any inappropriate comments to Sarah, and certainly wouldn't have put a rat in her drawer. And I will be honest with you, when I met Bob, I kind of thought Sarah's story was credible, but when I met Mac, I really gave Bob the benefit of the doubt. Mac, I really believed him. I thought, okay, this guy's level. This is okay. I'm feeling good about this story. Well, the case proceeded, and as we went through depositions and other matters, it always seemed like Sarah was one step ahead of us. She seemed to know more. She seemed to kind of be in on our strategy, and she was actually continuing to work in the facility. Even though she had a sexual harassment matter, she was still an employee, and Bob and Mac were still there as well. And so, I kind of assumed that there were other workers in the facility that maybe they were passing her information or whatever, but didn't know who it was. And the case went on more and more and more. And finally, though, it became clear that the source of Sarah's information was Mac. Mac was playing both sides against the middle. He would tell me things that he had heard from Sarah, and he would tell Sarah things, and Sarah's attorney things that he had heard from me. And so it ended up that it was actually Sarah and Mac who had the personal relationship, the romantic relationship, and they were keeping it a secret, and they were kind of in cahoots against Bob. So you can see how Mac kind of cleverly set me up to believe Bob. But if it had gone to trial, and I won't go through exactly what happened in this case, but it's likely that Mac would have turned and suddenly would have been saying, oh, yeah, Bob was all the time making gross jokes, and I absolutely could see him putting a rat in Sarah's drawer. And we would have been completely unprepared for that because we were believing everything that Mac said. So the takeaway from this is sometimes witnesses who appear to be friendly, who appear to be on your side, may not be, or at the minimum they may have complex loyalties. Yes, they may be largely on your side, but it doesn't mean they're completely on your side. So that's why it's helpful to box in the witness. You always ought to assume that the witness might change the story, might change sides, and you want to be sure that you have fixed it to the extent that you can, that witness is boxed in. You'll also want to confirm contact information. Telephone numbers, and not just their cell phone or their landline, but also their office number, perhaps another member of their family's number, if it's possible that numbers will change over time, a home address, or the post office box, that type of information. Email addresses can also be helpful. It may be that this case won't go to trial for several years, and it could well be that this person has moved on by the time it's time for trial, and you want to find this person. Well, they don't live at that previous address, and they don't work at that place of employment, and they don't have that same telephone number, so it may be tricky to track them down. It can be done most of the time, but it's helpful to know other members of the family's name, various addresses the person might have lived in, those types of information, so that you will find it easier to track the person down. It's always a complex question to decide what kind of statement, if any, you want to get from a witness. You certainly can prepare kind of an informal statement where you take careful notes, and you prepare a memorandum, and maybe you have the witness initial it, maybe you don't, but that records what you understood the witness said. Sometimes you want to have a more formal statement where the witness actually reads it, makes any corrections to the document, and signs the statement. And if you really want it very formal, you may actually have it notarized. And when it's notarized, it acts as a sworn statement, which can be admissible in court under certain circumstances. It's very possible that you will become a notary public and have the ability to notarize documents. If you don't, certainly someone else in your office will be able to do so. The more formal documents, the ones that are actually signed by the witness, whether they're notarized or not, can, under certain circumstances, be discoverable. So it may not be a good idea to always get those. Always talk to the supervising attorney before you do that. Your own personal notes are unlikely to be discoverable. They're much safer from that perspective. You will sometimes want that notarized document to be an exhibit to a motion that you might file. And so you'll want to think about what you want in that notarized statement. You want it to include everything you need it to include, but you may want to not share every single piece of information that you have. So there are a lot of strategic calls to make with respect to getting sworn statements. And again, something good to talk to the attorney about. This is from the textbook. This gives you an example of the type of information that you include in a witness statement. Obviously, you wouldn't do it in bullets. You do it in complete sentences set up in paragraph format. So we've talked about individual interviews that you might do, but many times you'll be charged with doing an entire investigation, which may involve both many interviews as well as document accumulation and other data that you might need. And so it's important to have a game plan from the beginning so that you make sure that you get everything that you need and you get it in a timely way. So it's good to have kind of a roadmap or a plan to attack. It's usually going to start with the familiar points. And usually this is going to be what your client knows or what information he or she has about the situation. And you're likely to want to create some type of investigation plan. If your law firm routinely handles that type of matter, for example, the car accident cases, there'll probably be kind of a prepackaged plan that you'll be able to dust off and apply to those facts. And you can use it as kind of your roadmap to know the things you need to find and also to keep a checklist. Let me flip to the next page so you can see. A checklist. So you'll write the date that you requested the police report, and you'll write the date that you received it. If you requested on January 17th and it's February 17th and you haven't gotten it, well, probably would recommend that you follow up with the police department to see what the reason going forward is. So here are some things that you would do to get these items worked out. And again, there may be additional ones that you have. And you can see in this case, the actual names of the witnesses are included in this. So you'd want to customize it. Obviously, there wouldn't always be a Tony Pareto or a Michael Young involved in every case, but you would want to make sure that you identify all of the witnesses, et cetera, et cetera. Let me go back to this first page. It's a good idea to talk with the attorney about what the investigation plan is. There may be certain things that the attorney wants to do himself or that he may want you to wait to do either because of expense or because of some strategic issue. And you'll want to probably use many different sources of information, from witnesses to subpoenaed documents to other records. Other records that you might find of value. Here's another page of that investigation report. And again, this is just an example that might give you some ideas about what it ought to contain. And you're likely to want to locate witnesses. The Internet is great for this. The Internet is a tremendous resource for paralegals in finding information out about people. There is a lot of inaccuracies and old information found on the Internet. So it's not the case that it's perfect or it's always going to point you immediately to the right answer. You may find, for example, that you're looking for Tom Greenberger, and you might find there's 3 Tom Greenbergers in the telephone book or on the Internet. Well, obviously only one of them is the one that you want, so you may end up calling 2 people that aren't the Tom Greenberger you need. Or you might find on the Internet that there's a Tom Greenberger who's lived at several different addresses. Well, it might all be the same Tom Greenberger, but he's only living in one address now, and you might find that you reach out to these various addresses and several of them don't end up panning out. So it's not that the information on the Internet is always accurate or always current, but it's an easy way to find out a lot of data, and usually the accurate information will somewhere be buried in that data. And usually it's fairly easy to cross off the data points that are no longer accurate or perhaps never were accurate. You can use the Internet, but you can also contact neighbors. There's lots of online people finders. Lexis and Westlaw have those as well that you can do with it for a relatively low expense. And then there are things like property records. In Texas, most urban counties, including Collin, Dallas, Tarrant, and Denton, have the appraisal district records online. So if you know that somebody lives in Collin County, they own their own house, it's a very easy task for you to find out where they live. You can also find out if they own this house with someone else, and you can also find out the value of their house, the size of the house, things along those lines. If they have a mortgage on the house, that type of information. And of course, that's a government record, but there are other government records that might be of interest. Many times public records are available at either no expense or a very modest expense for you to find. And one way to get that is through a FOIA request. A FOIA request is actually a reference to the Freedom of Information Act, which is a federal law that gives us, the tax-paying citizens, a right to access many different public documents. Not all public documents, but many. There's a similar law in Texas that accomplishes the same thing for state records. We are going to talk, I guess, a little bit about the evidence rules. This is a very big topic, and we will talk more about this in class, but I want to introduce these ideas to you. During an investigation, in some sense, you aren't concerned about the rules of evidence at all because you aren't appearing before a judge. You're just gathering information. So you may think to yourself, let the attorney worry about how the rules of evidence will allow him to get this piece of evidence in or will preclude him from putting this piece of evidence in. But even though it doesn't directly affect the performance of your investigation, it still has very important implications for you. For example, if you find out a piece of information, but the way you find out about it is not admissible, then you'll want to think about how can I find out this information in a way that's admissible. Let me give an example. And this has to do with the hearsay rule. Imagine that I am the paralegal. I'll call myself P for paralegal. And I'm interviewing witness Bob. And Bob tells me, he uses these words, Sally told me, and he goes on to tell me what Sally told me. Maybe Sally told me that she saw the car accident and that Larry caused it. Well, I'm finding this, and let's say I represent Bill, who was in the accident, and Bill is suing Larry about it. So this is a good piece of information for me. But it isn't immediately helpful for me because Bob is not going to be permitted to sit on the witness stand and testify about what Sally told him. According to Bob's story, he has no firsthand knowledge one way or the other about what Sally actually saw or whether Larry is in fact responsible for the accident or not. So in some sense, what Bob has just told me is not going to help me immediately with developing the case that's going to win the jury over on our side. But it can help me if I do a little bit more legwork, which is I need to find Sally. And if I interview Sally, and I can say to Sally, hey, Sally, Bob told me that you told him that Larry caused the accident. Is that what you remember? And if Sally says to me, why, yes, Larry did cause the accident, let me tell you why I think that's the case and what I saw and how I know this to be true. Well, of course, the things that Sally herself personally experienced through her five senses, she can testify to. There's no hearsay exception for that type of testimony. So Bob led me to a witness that would present evidence that would be admissible at trial. Now, if I were a paralegal that didn't understand the hearsay rule, I might have stopped with just hearing what Bob said and think, yes, we've now got some good evidence that will allow us to win our lawsuit against Larry. But if I know about how the evidentiary rules work, I will realize, well, I found possibly some good evidence, but I'm going to have to get Sally in the loop as well. Many times it seems in criminal cases, you hear this in television shows, that a big fuss is made about the distinction between direct evidence and circumstantial evidence. In real life cases, the distinction between these two can really be overemphasized. Both direct and circumstantial evidence in those cases are admissible. Certainly direct evidence is more likely to be admissible than circumstantial, but really in most cases both are going to be admissible. It sounds like direct evidence is better than circumstantial evidence, and in many cases it is more believable, more credible, more likely to sway the jury. But that's not always the case. Let me give an example. Let's say we'll go back to the example of Bob, who had 50 priests and rabbi and imam and ministers present, and they all testified that Bob was there. Well, when Bob testifies, no, I wasn't there. I was across town. I was in my bedroom all by myself. He is giving direct evidence. Even though nobody believes him, he is presenting direct evidence. But it's not credible direct evidence. He can testify to it, but the odds of the jury buying the story is very, very small. But let's look at it. So direct evidence can be very suspicious. But let's look at circumstantial evidence. Imagine for a second that the question is whether Bob was in downtown Dallas at 11:17 p.m. That is when there's some evidence that there was a hit-and-run car accident, and someone believes that Bob caused it. Well, it ends up that the accident happened at 12:17 p.m., but at 12:23 p.m., Bob's toll tag went through a toll tower at El Dorado and the tollway in Frisco. Well, there's no way that Bob could have traveled that far of a distance from downtown Dallas to North Frisco in 6 minutes. Now, it's possible that Bob loaned out his toll tag to someone else, and so it really wasn't his car, but the toll tag reader would have taken a picture of the car, and it won't be the clearest ever, but let's assume that the picture that the machine took seems to be Bob's car. Well, it's possible Bob gave or loaned his toll tag to somebody who has a similar car. But, of course, if it's a hit-and-run case, probably Bob wasn't planning on getting involved in a hit-and-run. And let's assume there's no reason to suspect Bob intentionally hit and ran this person, but that it was a genuine accident. Well, Bob wouldn't have been able to anticipate, I'll need an alibi. So that evidence of the toll tag being run through the toll tower at El Dorado and the tollway is circumstantial evidence. It doesn't prove Bob was there, but it's really pretty powerful evidence. That would be much more credible than the fact that Bob says, oh, no, I wasn't in the room when the 50 priests and rabbis say that he was. Let's talk about these three things that evidence needs to be. It needs to be relevant. It needs to be relevant to the case. And the relevancy standard is, does it tend to prove or disprove a fact in the case? And it can provide either role. So Bob's testimony that he wasn't there tends to prove he wasn't there. It may not tend to prove it a lot, but it may tend to. The evidence of the priests and rabbi and imams who said that Bob was there would tend to disprove what Bob is saying, that he was there. All of that would be relevant. Relevance really doesn't look at how credible the evidence is. In order to look at relevance, you assume that whatever the evidence is going to be believed by the jury. And if it is believed, would it likely sway the jury in how they evaluate the case? Is it relating to a material fact in the case? Another thing is that the evidence has to be authenticated. Now, of course, a witness testifying is authenticating his or her own testimony. But let's say it's a document or some other physical type of evidence. Well, you have to be able to establish that it's the real thing, that it's not a fake or a forgery or something along those lines. It needs to be authenticated. And you'll see many times in cases there will be a period of time in the presentation of the case where many times it said a document will need to be proved up. There will be certain specific questions that have to be asked in order for that document or piece of evidence to be admitted to court. For the most part, it's something the attorney is focused on, not the paralegal, but you'll hear those terms being used. It's helpful for you to have a context for it. Also, the evidence usually cannot be hearsay. Now, there are plenty of exceptions to the hearsay rule. Erase this here. But as a general proposition, the way that I like to think about hearsay is we'll make this Bob. I'll do one of my great art projects. Anyway, Bob is sitting here. He's in the witness stand. He's been sworn in, and an attorney is asking Bob questions. And Bob opens his mouth, and he starts with his response. And he says some name. We'll say Pat. Pat told me, or Pat said, or whatever. Pat told me that, and then wants to go on from there. Well, in most cases, that is going to be a hearsay situation because Bob here isn't testifying to what he has personal knowledge about. I mean, he has personal knowledge about what Pat said because he heard it with his own ears. But he doesn't know whether Pat was telling the truth or not. Maybe Pat was lying through his teeth. Pat wasn't under oath when he said that. And even if Pat had been under oath, just because a person is under oath doesn't mean that they actually are telling the truth. It means they're supposed to, but many people do lie under oath. And the jury isn't able to see Pat and see whether Pat gave some indicia that he or she might not have been telling the truth. And so because the jury isn't put in a position where they can evaluate Pat's credibility, it's not appropriate that that get into evidence. Bob might be the most gullible person in the world. He believed Pat, but nobody else on planet Earth would have believed Pat. So generally speaking, hearsay is not admissible unless an exception applies. Now, the reality is there's lots of exceptions to the hearsay rule. And here's a list of several, but I'm only going to hold you responsible for these 4 that I've put an arrow on. This list of hearsay exceptions are available in the textbook, but the ones I care about you knowing are excited utterance, business records, dying declarations, and statements against interest. I'm going to go on to the next slide. We'll talk more about these in class. But here's a short definition of what excited utterance is. It's a statement relating to a startling event or condition made when the declarer was under the stress or excitement caused by the startling event or condition. He says, oh no, the brakes aren't working. The reason why it's admissible, the reason why it's believable is that because it's a startling event, the person hasn't really had the time to come up with a lie about the circumstances. And because even though it's hearsay, they it's unlikely, it's quite believable that they're telling the truth. Another example is business records. Imagine, for example, that I am trying to kill my boyfriend, and I have decided to use rat poison to kill him. And so I have gone to the Walmart, and I bought a gallon of milk, a loaf of bread, and a box of rat poison. And I'm checking it out. It's a busy day at the Walmart, and so the clerk who's reading my stuff really isn't paying that close of attention. She waves the wand over the stuff, and it doesn't even register with her that I'm buying rat poison. And she checks out 100 people before I go through the line, and she checks out 100 people after I go through the line. Well, a couple of months pass. My boyfriend is dead from rat poison. The police are on to me. They're trying to figure out, how did Gruber do it? How did she kill her boyfriend? And so they're looking into various leads, and they think, it's possible that Gruber went to the Walmart and purchased rat poison. Well, if they interview the clerk isn't going to remember me. It isn't going to remember the transaction, and certainly isn't going to remember the rat poison. Months have passed. She's rang several hundred people since then, and very possibly, if Walmart even has security cameras, they've been deleted by this point. So the clerk isn't probably going to have any first-hand recollection. But let's assume that I wasn't the smartest person in the world, but I used my credit card to purchase the rat poison. Well, Walmart will have a record of that transaction in their records, and it'll be associated with my credit card number, and it will show the gallon of milk that I purchased and the loaf of bread I purchased, and it will also show a SKU for the rat poison. Now, I will be able to say, well, that wasn't me. I don't know why that's on my bill. And the clerk, of course, won't be able to say, yes, I remember ringing that, because she doesn't remember ringing it. But there's no reason that Walmart would try to frame me. They would have no reason. I have no business reason why they're angry at me or anything like that. So under those circumstances, business record exception to the hearsay rule, that would be allowed in. Let's look at the formal business records rule, exception to the hearsay rule. A document or compilation of data made in the course of a regularly conducted business activity, like the clerk ringing my transaction, unless the source of the information or method or circumstances of the document's preparations indicate that it is not trustworthy as evidence. The source of information must be from a person with first-hand knowledge, although this person need not be the person who made the entry or created the document. For example, financial statement of business firm or transaction receipts. Let's look at statement against interest. If I say something, let's go back to the example. Bob is testifying, and he says, Pat told me that, and the rest of the sentence is, Pat told me that she murdered her husband. Well, usually people don't confess to crimes that, under those circumstances, because guess what? Say, in fact, did it, because guess what? It's not going to help you out too much to confess to a crime that you didn't do. So a statement against your personal interest, a confession or something similar to that, is usually held to be quite believable. Let's look at what the textbook says about it. A statement against interest is a statement that was made by someone who is now unavailable and that was at the time of the making so far, was at the time of its making, so far contradictory to the declarant's financial, legal, or other interests that a reasonable person in the declarer's position would not have made the statement unless he or she believed it to be true. And here's the example. Sanchez says that Jackson, who is now missing, made the following statement to Sanchez before leaving town. I committed a perfect crime. Why would Jackson say that unless he in fact does feel like he committed a perfect crime? And the last category is the dying declaration. This has a lot of cultural associations. And so people that come from a Christian background have a set of beliefs many times about their final moments on earth that causes this belief in the dying declaration exception to make sense. Imagine for a second that I have been fatally, mortally injured. I know that I'm dying, and I know that I have very little time left on this earth. Well, the idea in the Christian religion is that I am most likely concerned about my eternal fate because I know I'm about to face final judgment from God. And so the last thing I want to do is have my last action on earth before I die be a serious sin. And telling a lie at that moment would be a serious sin. So I am more likely focused on my eternal fate more so than in protecting some interest I might have on earth. I'm thinking more about heavenly things than earthly things at this moment. At least that's the belief that many people have with the dying declaration. In order for the dying declaration exception to apply is that the declarant has to know that he or she has been mortally injured, has to actually die shortly after making the statement, and the cause of the death is related to what the statement is that the declarant is making. So here is what the textbook says. In a prosecution for homicide or in a civil proceeding, a statement made by a person that believes that he or she's death is impending about the cause or circumstances of his or her impending death. For example, Derek just said before he died, Jethro stabbed me. The idea being, even if Derek really hates Jethro and wants to frame Jethro, he's not going to lie about that right before he dies because he doesn't want to go to an unpleasant place upon his death. Nobody hates another person so much that he'd be willing to allow his own soul to be damned, is the idea behind it. Okay, so you've completed your investigation. You've looked at all the evidentiary issues that come up. You've gathered your data. You've interviewed your witnesses. And now it's time to present some kind of summary of your findings. You may do it in a couple of different ways. A common one is to do it source by source. You'll have a section on your interview of your client. You'll have a section about your interview for each one of your witnesses. You can also present it in a different way where you tell the story chronologically. So you might, at the beginning of the story, have some information from your client, and you might have some information from witness number 7, and you might have some information from witness number 2. Of course, each one of those facts, you want to have some kind of parenthetical note that says where you got that information from. But probably more common, it's going to be source by source. In this document, you may point out some problems in the testimony areas where they didn't seem to have a clear recollection or their testimonies seemed to change over time, and reasons that they might not be believable to the witness, to the jury. And you'll also want to include some recommendations. Or might be next steps. Are there certain motions that ought to be filed? Is this a good time to start thinking about settlement? Things along those lines. And then basically you're done with the investigation. Here's a summary of the things that we've talked about. Well, I'm going to leave this up here for a second just so you can fill in the blanks for your study guide. And I'll go, if you need to pause this, go ahead and pause this. I'm just going to keep on flipping through this. To make sure you get the blanks. But again, if you need to pause, go ahead and do that, and I want you to get all the information. And if you have any questions about this presentation on Chapter 10, either the first or the second presentation, please bring them to class so we can talk about them. Thank you for your attention. I hope to see you soon in class. Take care.